Welcome, everyone, to CBIA's HR Hotline Live. Today, we'll be talking about employee disciplines and terminations. I'm Diane Mokriski, HR Counsel here at CBIA. I'm joined by two partners at Carmody Torrance Sandak Hennessey, Vincent Farisello and Nick Zaino. Vincent and Nick both have extensive experience advising Connecticut businesses on all things employment law, including, of course, issues relating to discipline and terminations. Hi, Nick. Hi, Vincent. Thanks for joining us.
Thanks for having us.
So this is an HR hotline, so we won't be presenting slides or making a general presentation. The idea is for you all in attendance to submit your questions in the Q&A. We do prefer the Q&A and not the comments, and we'll address as many questions as we can in the next hour. So as you all are thinking of your questions and sending those in, Nick and Vincent, let's just start, if we can, with the concept of progressive discipline and performance improvement plans. Are there any situations where you definitely recommend them or definitely don't recommend them? Are there kind of some pros and cons that you can think of?
Yeah, definitely. I'm going to start, I think, with the concept of progressive discipline, which I think is a really good rule of thumb for an employer to address an employee's performance issues, but also misconduct, breaking rules, that kind of thing. What's really important about it, though, is the idea that it be implemented with flexibility. I think it's important to, to sort of design a progressive discipline policy that allows for that flexibility. And when we say progressive discipline, what we're talking about is, trying not to abandon the idea of dealing with performance or misconduct issues on a case-by-case basis, but having some guidelines for how we're going to address it and progressively dealing with those disciplinary issues. But again, got to be careful not to turn it into some kind of promise, into some kind of contract. We've put together really good progressive discipline language that makes really clear that, we reserve the right to, skip steps, advance to other steps, repeat steps. I kind of also think it's important to think that whatever the consequences should kind of fit the offense. Some might say the punishment fit the crime, as it were, but also take into account other contextual issues. What's the employee's performance history? What's their employment history? What other kinds of things are going on in the background? But again, the key is design for that flexibility, preserve the employment at will status, and be careful not to create some contract or promise of some ironclad kind of process. As for performance improvement plans, there's definitely some advantages and disadvantages to those. On the plus side, I think, and when we say a performance improvement plan, what we're talking about is, a more formal but structured type plan that's for, that's designed specifically for an employee, that outlines what that person's performance issue is, and then also concrete steps for how they can improvement. And usually it's within a sort of limited period of time. So some advantages to that, I think it sends the message to employees that, hey, this is a fair process. We are providing support. We're giving you an opportunity to improve. And it shows a real open line of communication. And it gives it gives some confirmation that we're not going to just jump to, in most cases of performance issues, we're not going to just jump to termination without some warning. I also think another positive is that it puts the onus on the employee to take ownership for that issue and for how to correct it, or to actually take the steps to correct it. We'll give you ideas on what needs to happen, but it's up to you to actually do it. And guess what? In some cases, the person does turn it around and they are able to become successful. On the flip side of that, got to keep, if you're going to go into it as an employer, you've got to recognize that there's going to be time and effort that the employer has to put in, whether it's through the supervisor or the manager or whatever. It's not going to be one of those things where you just put it in writing, put it in a file and then go revisit it in the 30, 60, or 90 days. There should be some follow-up and actually putting the time and effort into it. Another risk, I think, and this can be addressed in how it's communicated to the employee, is that this shouldn't, kind of be a quote unquote kiss of death, right? This doesn't mean that this is ultimately definitely going to result in termination. But you've got to let the person know that it is serious enough that changes need to happen. But there is an opportunity for the individual to turn it around. As for cases of when it is or isn't appropriate to use a performance improvement plan, as the name would suggest, I think they're best used for actual performance issues, not so much for misconduct or disciplinary issues or significant rules violations. I know before offline we were talking about an example you had where an employee was, an employer was dealing with an employee who was just being really awfully rude and obnoxious to customers. I'm not sure that that's necessarily the most appropriate use of it. But if it's an employee who's trying but struggling to meet, for example, production quotas or getting reports done on time, I think those are the types of things that are really more appropriate for a performance improvement plan.
Okay. Nick, do you have anything to add to that?
The only thing I would just add, because I agree with everything you said, Vincent, just on progressive discipline, yes, I do like to see progressive discipline as a general matter. That doesn't mean there aren't situations that warrant immediate termination. There certainly are, where you don't need to go through progressive discipline. The only thing I would add is you have to be consistent. And so keep in mind that if you follow progressive discipline for one employee on performance issues, you give them a warning, you give them a written warning, you give them a final warning. You want to ensure that somebody else who is similarly situated is also given progressive discipline, not necessarily in exactly the same way, because no two situations are alike, but to just be aware that, the hallmark of any discrimination claim is somebody claiming they were being treated differently. And so you do want to ensure that your actions are consistent, or if they're not, there's a good explanation why they're not.
Mm-hmm. Yeah, and I think to piggyback on something Vincent was saying, I mean, it's not a guarantee. Obviously, it's not a guarantee that you're going to not be fired, and it's not a guarantee that you will be fired, right? And so it'd be really inappropriate. I think sometimes employers use performance improvement plans where the improvement has to be extraordinarily drastic. It just seems completely unrealistic, right? And that guy's never going to meet that performance improvement plan. So if there's, it would not be appropriate in that circumstance, I don't think. So, it's got to be, a good faith plan, right, where the person can actually meet it and stay employed if they can comply.
Yeah, and I would also, to piggyback on that, I would also say that you do have to have that good faith. We're going to give this a real try here. If the decision's already been made to part ways, I don't like the idea of using this as just an effort to paper the file, as it were. I think if you're going to think about doing one, to your point, it's got to be because it's got a possibility of working, A, and B, you as the employer are willing to put in the effort and the support to possibly make that happen. And one last, sorry.
No, go ahead.
One last point, I don't mean to shift gears, but on the progressive discipline, I talked about flexibility. We want to have some idea of how it would work, but don't get paralyzed into or thinking that it's so ironclad. Back to the point of the punishment must fit the crime. Just using a horrible example of someone who got caught stealing from the company. And I've seen some employers get tripped up on this. Oh, well, there's been no progressive discipline before, so do we have to start from the beginning? Of course not. That's the whole point of building in the flexibility into the policy.
Mm-hmm. So what about the question, would you say that a PIP is appropriate for absenteeism and tardiness? What do you think about that?
I think it can be. It might depend on the circumstances, what's behind the absenteeism or tardiness, but I've seen that before, and I've seen it be done successfully before as well.
Mm-hmm. Yeah, maybe just it'd be a way of alerting the employee that, you know that they've been late, you know that they've been absent. This is something that's on your radar and it's got to improve in the next X amount of time. So yeah, I think that would be workable. So let's talk about unemployment. Do you see that question? So how do I submit terminations to the state, and what's the process of notifying the state that an employee left without notification and would not be eligible for unemployment? So can you talk a little bit about resignations, not showing up, terminations, and how that affects unemployment benefits?
Yeah, so in the most basic of terms, I think of unemployment benefits as an income replacement benefit for folks who are unemployed through no fault of their own, in general, but in the most basic of terms. And so, the idea is if someone is voluntarily leaving suitable work, and there isn't something the employer did to cause that a voluntary resignation in and of itself generally would make someone ineligible for unemployment. Similarly, if the employer terminated employment because of something bad, i.e. some kind of misconduct that the employee engaged in, that may render them ineligible for unemployment. If, on the other hand, the employer terminated that employment through no fault of the employee, something like a layoff or a restructuring or just a termination for convenience or whatever you might want to call it, that generally would make the person eligible for, could make them eligible for unemployment. As for the question of, I see it from Nancy here, how do you notify the state of that? Well, one thing to keep in mind is, regardless of the reason of separation, whenever someone separates, there is a legal obligation to provide them what's called an unemployment separation packet. Sometimes I think it's the form number is UC 61. It does a few different things. You do put some very basic information there about the separation, but it gives the employee notice of their rights to file for unemployment benefits. The onus is ultimately on the employee to file for those benefits. But through that process, the employer will certainly have the opportunity to provide their side of the story of what caused the separation. And ultimately, it's going to be up to the state to decide whether the separation qualifies the employee or the former employee for benefits or not. It's not the employer's choice. It's the state's. The state will look at that based on what you, the employer, say and what the employee does as well.
So when you have, like in Nancy's situation, if you have an employee who just stops coming to work, and so the employer sees that as a resignation, do you advise your clients to then send out what we used to call the pink slip? Even in that scenario, you just send that out in the mail, letting them know, like, this is what you use to file.
Yeah, it's actually supposed to be given to the employee, not to the state. And the employee is supposed to take that pink slip and then go file their claim for benefits. That's the idea behind it. And as Vincent said, employers are supposed to do it in all separations, in all employment separations. So you can give the employee that UC 61 form and indicate voluntary resignation, and the employee can still go ahead and file and dispute that and say, no, whatever their story is. And then it's up to the DOL to hold a hearing and decide whether or not it was a voluntary resignation, either with or without good cause attributable to the employer, or a termination.
So when you let someone go, whether it's a layoff or a termination or a resignation, there's nothing that the employer has to send in to the Department of Labor?
That I'm aware of, no.
Yep. Right, okay, so you're just giving the pink slip to the employee, and then it's the employee's job to file.
Correct. Yes, and they can file without the pink slip too. And I think some employers, do not provide the pink slip, either out of just not knowing or just for whatever reason it's not provided. It doesn't prevent an employee from filing. The DOL will still go ahead and accept that filing and process that claim for unemployment.
Okay, so let's go on to Mary Ellen's. I have a new employee who's called out sick 2 out of the 5 days he was supposed to work, and the manager wants to terminate him. Probably I would have a few more questions, but what do you think? Where would you start with that?
Well, the first question I would have is why did they call out, obviously, right? Is it a reason that might be protected under the Family Medical Leave Act or some other medical issue? Just is it something that might be protected? And if it is, of course, then terminating would be risky, right? Because it looks like you're terminating somebody for a protected absence, whether it's one of the absences or both of them. Certainly for both of them, I would not advise moving forward because they're protected. If they're not protected, they're not job protected absences. My next question would be, just want to know how you've treated others. If there are any other similar circumstances where this has come up, what have you done in other situations? Just to ensure, again, that we're treating people consistently and you're taking a consistent position. What practice do you want to establish going forward? And I would also want to ensure that the offer letter said that employment was at will. We get this sometimes when an employer wants to revoke an offer after somebody leaves employment, and it's really important that the offer letter make clear that employment was at will. And if both of them are not job protected, they're just my car broke down and having nothing to do with any kind of job protected leave, or I just overslept, and the employer says, look, 2 out of 5 days, we're off to a really bad start, this isn't going to work out, I would be okay with that. That would be okay. But if they're, but I just want to know those other issues.
Mm-hmm. Yeah, and I guess the fact that it's a new employee is telling. But if it was not a new employee, you'd want to check. They may be entitled to sick time, Connecticut paid sick days, right? And,
exactly.
and FMLA and ADA. So there's all those things that you want to. And I do think there's a common issue where you have the manager versus the HR manager, and the manager is so frustrated with people calling out sick, so they just fire them. And the HR manager is the one saying, wait a minute, there's ADA and there's FMLA and all that. So yeah, it's important that the manager and the HR person communicate about stuff like that. All right, let's move on to the next one. We have an employee that has recently been given a verbal and written warning. And while being counseled during the warning process, the employee indicated that they have an attorney on retainer. Okay, we haven't responded to that particular comment or taking it as an idle threat. So should we address that or ignore that?
My reaction to that is we don't know if it's an idle threat or not, but I'm not feeling terribly compelled to address that or respond to that specific piece. Hey, everybody has a right to engage or retain an attorney if they so choose. But if this is a bona fide, legitimate, good faith reason for why we've gone down this progressive discipline path, then I think you've got to continue doing it. I don't think the fact that they have an attorney should deter you. I think you should have a heightened sense of awareness and internally scrutinize yourself and what you're doing. As a best practice, perhaps even in the background, consult with your own counsel, get a second opinion on it. But I don't feel terribly compelled to address that directly with the employee. It's their right to do.
Yeah, no, I'd actually just document that conversation, because the fact that they have an attorney on retainer is kind of telling, perhaps.
Mm-hmm.
So, yeah. All right, so what are some examples of discipline other than a written warning? Can you restrict hours, benefits, reduce pay?
Yeah, so those are kind of like benefits. I don't know about benefits. Like benefits may be governed by your benefit plans, right, as to whether or not you have any latitude there. But reducing hours or pay, typically those aren't used as a way to discipline somebody. Like you don't necessarily discipline somebody by cutting their pay. Not that it can't be done, but I don't think most employers do that as an effective means of discipline. Or same thing with hours. It doesn't mean it couldn't be done in the right circumstance. It's hard to answer that in the abstract. It's just not typically part of an employer's progressive discipline approach. Typically, it's communicating to the employee what the performance issues are, either verbally or in writing, and giving that employee an opportunity to correct that. And if they do, great. And if they don't, then you step up and you continue down that disciplinary road. Not saying there aren't circumstances where you can do that, take other alternative methods, but it's not typical. It's not the typical progressive discipline response that most employers follow.
Yeah, and I guess there would also be just that risk if they were exempt, right?
True.
And you can't necessarily not pay the person. So you would want to be careful about that as well. Were you going to say something, Vincent?
I was just going to say, I was going to make that exact point on the exemption issue. I was also going to say, other possible consequences are, could be, again, subject to the caveat for the exempt employees, paid or unpaid suspension. But in the context of a reduction in pay, maybe it's part of, if this is a long pattern, there's a history of this, maybe the position's not the right fit for the person. Maybe it's a movement to another position or a demotion that winds up resulting in a reduction in pay if it becomes really clear that role isn't the right fit for that person.
Mm-hmm. All right, the next question from the anonymous person, I get a lot, the probationary period. If you're at will and an employee is terminated during the first 90 days, which a lot of people consider probationary, and we can talk about that, how do you avoid being responsible for unemployment?
I don't think you, as an employer, the fact that you may have a probationary or introductory period, that's your own internal policy. That doesn't have any bearing whatsoever on what the state will take into account when it's making its determination about someone's eligibility for unemployment. The fact that the employee has only been employed for such a short period of time with you, I mean, your role here will be, trying to determine whether the separation qualifies the person for eligibility for unemployment benefits. But since they were, in this case, in this example, employed with that employer for such a short period of time, there may ultimately be very little, if any, liability that the employer has vis-a-vis with regard to their experience rating if the person is ultimately eligible and they do have enough earnings over the last however many calendar quarters they look at to determine someone's eligibility. So, it's for purposes of the separation, there's nothing you can do to limit your role in it, and the state will care about what the nature of that separation was. Was it due to the employer or to the employee? The state's not going to make the determination based on the probationary status.
Yeah, and what is it? It's when the Labor Department is trying to figure out if an employer is going to be responsible for that person's unemployment, it's the first 4 quarters of the last 5 most recent quarters.
It's the first 4 of the last 5 completed quarters.
Yeah.
So
he may not be eligible anyway, right? If he's only been working 90 days, it kind of depends how far in employment he is.
That's right. Right. Exactly.
So, all right. So let's move on. Is it true that the employee has to demonstrate willful misconduct in order to not be eligible for unemployment? For example, an employee within their first 90 days is not able to perform the job and we terminate. Yeah. Are they still eligible for unemployment?
Go ahead, Nick.
No, that's okay. You addressed that earlier, Vincent, so you can pick up on that. I was just
gonna say that one of the things that would render an employee ineligible is misconduct, not poor performance or a demonstrated inability to do the job. That's more of a performance issue. If an employee is let go because they're just not doing a good job, not with misconduct, just poor performance, that's likely going to make the person eligible. They're likely going to be eligible for benefits. But the way to look at it is, if your position as the employer is that there's some willful misconduct that happened here, that burden is on the employer to show that the employee then engaged in misconduct and therefore wouldn't be eligible for benefits. But again, it's going to be the state that makes that determination.
Yeah, and one thing to just, I think sometimes there's a misperception with employers that willful misconduct is the standard you must prove in order for the state to conclude that somebody's not eligible for unemployment. It doesn't mean you don't have grounds to terminate from a legal basis, right? You may have perfectly valid grounds to terminate somebody's employment for poor performance or misconduct, but it may not meet the state's high threshold for determining willful misconduct. Remember, the unemployment system is there, the unemployment benefits are there for people who lose their job and they don't have any money coming in and they can't pay their taxes and they can't pay their bills. And so there is a very strong presumption of eligibility on a separation of employment unless the employer can meet that high threshold or the employee just chose to quit. And so the cards are stacked against the employer in unemployment, but intentionally so. It doesn't mean you don't have grounds to terminate somebody's employment. They just may be able to collect those benefits that all employees and employers pay into.
Yeah, and I think employers are sometimes surprised to learn that, I mean, I think the statute specifically says incompetence is
Right.
not a reason to be ineligible, right? So you can, even if you've been doing the job for a long time and then you stop doing the job well and you need to be fired, that does not make you ineligible. So in a sense, yes, she was right. You do have to, in order to be ineligible, you have to be guilty of willful misconduct. But that, as Nick said, that's the employer's burden to show that. Do you guys want to talk a little bit about the absenteeism and when that's willful misconduct? Do you know, like the 2 days versus the 3 days?
So under Connecticut law, being absent without notice, it can be deemed misconduct if the employee, for example, is a no-call, no-show for 3 separate instances within a 12-month period. Now, the current rule, which has been in place for some period of time, says that each instance in which an employee is absent for 1 day or 2 consecutive days without notice constitutes a separate instance. So, for example, if you had someone who was no call, no show for 2 consecutive days, that only counts as 1 instance toward the 3 instances in a 12-month period of time. If you had someone that was 4 consecutive days, that would count as 2 instances, because again, it's that 1 or 2 consecutive days. And so you could theoretically have someone be absent for 5 consecutive days, no call, no show, until they hit that 3, the 3 instances threshold. So that's always been kind of a quirky thing in the unemployment law. Fortunately, that's changing next year. I think it's January 1 of 2024, and the standard is going back to just each day of absence without either good cause or notice to the employer will constitute a separate instance. So we're going to kind of go back to a more literal interpretation there.
Yeah, that was always kind of screwy. So if you were a no call, no show on Monday, Wednesday, and Friday, then that was enough. That's 3 separate instances.
Yeah, right.
That was enough to disqualify you from unemployment. But if you were absent on Monday, Tuesday, Wednesday, and Thursday, no, that's not.
Right.
That wasn't enough. And so I think that's why that rule has changed. And I just saw, before we change topics, I just saw a question come in. Now I don't see it, but maybe it's in the chat. It had to do with, I think, can we just have a no call, no show policy that differs from what we just said? And so I think that's what you all were saying, just if someone if there's a no call, no show issue, of course you can terminate the person. We're just talking about whether they're eligible for unemployment, right? So an employer can come up with whatever no call, no show rule they want, but you're not going to change the Labor Department rule for unemployment.
Yeah, well said.
Yeah, I often see that in a handbook, it says if you're out for 3 consecutive days, no call, no show, we will consider it job abandonment. And unemployment has all sorts of rules about what constitutes job abandonment. And just having that policy does not make it job abandonment. You have to argue that a violation of that policy is willful misconduct. It's a single knowing violation of a workplace rule, reasonably enforced, all that stuff. So you can make that argument, but it doesn't mean it's job abandonment just because the employer's policy says it's job abandonment.
All right, what about Jamie's question? We just had an incident where an employee refused to read the written warning and he threw it on the ground. And they gave him the option to read and sign, and they ultimately fired him, and now he's trying to collect. So did they do the right thing in firing him?
Yeah, so keep in mind, in Connecticut, you have to give employees the option to contest a written warning. So you have to have language in there. It should be baked into all the disciplinary notices that give the employees the right to submit any comments that they'd like if they disagree with anything in that warning. So be sure to include that in any disciplinary notice. And you're going to have to show to Jamie, you're going to have to show, if you contest the claim for unemployment, that his actions in throwing the piece of paper on the ground constitutes willful misconduct, a single knowing violation of a workplace rule or deliberate misconduct. Like the definition of willful misconduct has other is also defined. So you've got to make that argument, that, and just try to add, if there are facts that demonstrate that it was really unacceptable. Maybe it was done in the presence of coworkers. Maybe there were a few choice words that were also thrown in there. Again, the standard is pretty high. So somebody getting frustrated and throwing a warning down and then walking away and being terminated on the spot, probably not going to hit it unless there's other facts that really make it, really egregious. That's my sense of it.
And one other point, related but a little unrelated, is just this idea of when an employee is presented some piece of discipline and they refuse to sign it, does that mean that they didn't get it? Of course not. You can't force someone to sign a written warning. You can let them know, of course, that all you're looking for is for them to sign to acknowledge that they've received it. But if an employee absolutely flat out refuses, and may even refuse to submit a statement contesting it, I think it's perfectly appropriate for you to document that it was given to them by just hand marking it yourself. Employee refused to sign such and such date, and then whether it's the HR rep or manager, just initialing or signing it themselves. So there's, I guess, this misconception out there that an employee refuses to sign if they didn't get it or it didn't happen. It's just not true.
Right.
All right, how about this one? We've had 2 employees in the past 6 months that start the job and leave for lunch and don't return. We did not receive their paperwork yet, so have no I-9 tax info, etc., in order to pay them. What do we do?
So the I-9 wouldn't be for the tax, that would be the W-4.
Right, the I-9 for immigration,
Yeah.
You do have 3 days to do that one. You have 3 days.
3 days.
Yep. So the employer would be okay there because the person left that day. The harder part is if you got none of the tax information, i.e. you didn't get the W-4 form, that would be, it's going to be difficult to withhold taxes at that point.
I guess the lesson there, if they're having an issue with that, the lesson there is you don't have the person start working until you get all their info. They sound like maybe they were kind of desperate for someone to get started, but the downside there is what the issue is there. You got to get all their information.
I'd probably write a letter. I'd probably tell the employer, let's assume it did happen, and for whatever reason they were anxious to get him started. You'd probably write a letter to the person saying, we have a check for your 3 hours of work this morning. Obviously the employer in this situation is probably not going to want to continue their employment unless they left for some emergency, but I'm assuming that's not the case if it's happening over and over. We have a check that we want to give you. You need to come in and fill out a W-4 form so we can properly issue you a check. You want to at least show that you're trying to pay minimum wage or their hourly rate that they were agreed to be paid.
All right, so let's talk about the onboarding process. And I do see an issue there to talk about after an interview, but before the onboarding. But before the onboarding, an employee is having a hard time making orientation and following the procedures. Can they just be let go? No hours have started, but they were told to attend orientation. For a second there, when I first read that, I thought the thing that I wanted to talk about was the fact that if you require someone to attend onboarding or orientation, they have started and you need to pay them for that.
Yes.
So I'm not sure if I understood that correctly. But what do you think about the rest of the question?
I mean, so start with the premise that if you're requiring them to be there and it's for your benefit as an employer, they have to be paid, right? They have to be paid their hourly rate. And then if they're just not, either they're not doing a good job in orientation, they're not paying attention, they're not doing what's supposed to be done, that would be reviewed like any other performance issue. Just because it happens during orientation doesn't mean it's treated any differently. In fact, there's probably a little bit of a higher expectation that during this orientation process, the person's going to be just right. So probably less tolerance for inappropriate behavior, but I would treat it like any other issue that's come up during employment and evaluate it on that basis.
Yeah, I mean, that sounds like a bit of a red flag to me. I mean, they can't even attend, they can't even do orientation correctly. You may have an issue there.
Correct.
Okay, so I have a manager who wants to suspend an employee who's exempt. We were just talking about this as a form of discipline. It is not pending the outcome and investigation because it's concluded that there was misconduct. So the suspension must be unpaid. Because the employee is exempt, does it mean that the suspension must be for the entire week in order to avoid having to pay?
Well, I think the anonymous is thinking about the right things because, exempt employees are subject to the salary basis test, which means that they must be paid the same salary week in and week out without regard to the quality or quantity of their work. And so very, very limited circumstances to when you can deduct for days not worked during a week in which the employee has done any work. In Connecticut, it's you can only do deductions for full days missed as a disciplinary measure if it's for violation of a safety rule of major significance. So if it's not that, then you can't really do it if the employee has otherwise worked during that week. And so, I think you kind of are down to the idea of having to do that suspension for an entire week to avoid having any liability. Then it begs any liability to pay the salary for that week. But then it begs the question of whether or not that again, does that punishment fit the crime at that point? I mean, that's a very, very significant consequence.
Mm-hmm.
Yeah, and I'd be very careful about unless the facts really demonstrate, deducting the salaried employee's pay for a violation of a safety rule. I mean, that carries with it a double-edged sword, doesn't it? And so I would do the full week. I would look to either the full week paid or unpaid suspension if that's really what you want to do, or pay the salary and just issue some sort of final warning or a serious written warning. Or I suppose, you could force the employee to use their PTO to account for, like, the state doesn't care whether they get their salary in the form of salary or PTO plus salary. Like, you could do that too. But again, those, I probably would stick with a more traditional way of disciplining an employee rather than addressing the pay, unless you decide it's serious enough to warrant an unpaid suspension for a week.
Yeah, that might be a good compromise, though, Nick. If you want the employee to feel the
pinch,
harm, right? So you say, all right, so you're still gonna get your paycheck because we have to do that, but you just lost a whole bunch of PTO, or a day's worth of PTO, whatever you decide.
Mm-hmm.
All right, so going back to PIPs, do you think that the question is, should that go in a handbook? I think that would be tricky, but let me go back up to that question. My employer has a section in the handbook, but it's vague, and she denied the employee's PTO request. I'm confused about that question now. Do you see that, either of you?
Yeah.
Do you understand that?
Yeah, my employer has a section. I don't know if I understand the question, but
Yeah, the PTO makes it a confusing question, right? So if you want to send that in again. What do you think about PIP guidelines in a handbook?
Me personally, go ahead, Nick. I don't want. Let me hear.
No, Joe, go ahead. Go ahead. I'm curious to hear your answer.
I want to know if I agreed with you. So go ahead.
I don't have a problem with including it. Like if that's something that the company has embraced, the employer's embraced, a performance improvement plan as one of its one of the tools that it uses to address performance issues. I have no problem with making a reference of it in the employee handbook that in the appropriate circumstances and from time to time, the employer may require that the employee, enter into a performance improvement plan to address performance deficiencies. Like I have no problem mentioning that in the handbook. It doesn't mean you have to in every circumstance, and it doesn't mean you can't. Like I think it's a fair thing to put employees on notice of.
The only thing about putting stuff in a handbook, it's hard to know exactly what they're talking about in this question, but a PIP is going to be pretty specific to each individual, right? And so it's not like, I don't know that you could say in your handbook, if you are given a performance improvement plan, then you will be given the following 3 chances and these following 4 things won't happen to you. And do you know what I mean?
Yes.
Because some may be more severe than the situation might be more severe. So I don't know, that would maybe, that merits more discussion, I think, depending on the circumstance.
Yeah, I'd be okay with reference to it, but I'd be reluctant to try to get into detail about it, precisely for what you just said. These are truly done on case-by-case basis, depending on what the underlying performance issue is, depending on what the history is. So you're not going to be able to have, in a good coherent way, a lot of detail in there anyway.
All right, so we've got a question about absenteeism again. It's a little bit different because in this case, so the issue is excessive absenteeism, but the person has called out according to their guidelines. And I'm wondering if that means, let's say you're allowed 6 sick days and they called in 6 times. So they didn't actually, so they're following the rules. So is that really excessive if they're following the rules? I wonder if that would be one of my questions in response to this submitted question. You see, if an employee has excessive absenteeism but's called out each time according to our guidelines, are they still able to collect unemployment, which is a whole separate issue? Nick, do you want to address that?
I'm interpreting that to mean they call their supervisor in accordance with the company's process for reporting absences, but there are a lot of them. There are way more than what the company normally allows. I think the standard you're going to have to show is, again, willful misconduct in that situation. I don't think that falls into the attendance rules that Vincent went over.
No, because that wouldn't be a no call, no show.
Exactly. And so you're going to have to show that is that amounts to willful misconduct. And, you get into kind of the details on that. Why is the person calling out so many times? And again, we're assuming it's not any kind of job protected leave. It's not intermittent FMLA or any kind of sick time or something that might be job protected.
Yeah, so I guess the willful misconduct, it doesn't sound on the face of things that would be misconduct. I guess if you isn't one example of willful misconduct like a violation of a known rule, right?
Yeah.
So if the employer had a very well publicized known rule that you couldn't call out a certain number of times and they did it anyway, you'd have a shot, maybe?
Yeah, I think, Diane, there is, and I'm just going off memory, but I have some vague recollection that there are DOL cases on excessive absenteeism as a disqualifying basis apart from the rules that Vincent was talking about. Like there just may be case law in the unemployment Board of Review decisions that addresses excessive absenteeism. So hard to answer in the abstract. I'm not saying you can't, it just depends how bad it is. But obviously the standard for unemployment has got to be pretty excessive in order to disqualify someone.
All right, so let's talk about proof. What kind of proof can you ask for? Typically, the employee's no call, no show, and then they say, my car broke down, or family emergency, or I was sick.
Again, it may depend on what that exact, what they claim exactly the nature was. If it's a sick related reason and the employer is covered, for example, by Connecticut's paid sick leave law, and the employee in question is a service worker, and so they're both covered by that particular statute, then the employer can't ask until the employee has been out for 3 days. But outside of that context, you can ask for some proof. I can't speak to what that might be in every specific case. I'm not sure, if it's a car breakdown kind of situation, maybe it's, okay, do you have, this is kind of going pretty far, but do you have some repair bill to show that you had to get the car fixed, or that you had to take an Uber to get here, or whatever. The type of proof you can ask for might depend on the exact nature of the absence, but I think you can outside of the context of that paid sick leave caveat.
All right, so the next one, we have an hourly employee that calls in sick once a week. Will that still qualify as a no call, no show since they're still calling in? And what discipline would qualify? So if they call in, it's not a no call, no show.
No show, right?
I don't know, call no show. Yeah, I think you're back to, what is the reason for them calling out sick once a week? I mean, it certainly sounds fishy. And so, it could very well, if it continues for a period of time, constitute willful misconduct that in fact, the person is just out so excessively that it meets that level. But again, I get unemployment hurts, like for employers, especially small businesses, your unemployment rate, goes up a little bit, and that's a significant issue for some small businesses. But if you have an employee that is not a good employee for your business, and is not going to is not an employee that you want working for you, and you're on solid grounds to terminate that employee's employment, I generally advise going ahead and taking that job action, even if it means that the employee is eligible to collect unemployment benefits, because the danger in keeping an employee who is not committed to working for you, is not doing a good job, not showing up for work for reasons that are not job protected, I think that can create more risk, especially if the relationship gets strained because the employer, is really getting upset, and the employee, it just takes one complaint that employee files to wipe away the cost of the unemployment increase in insurance. And so typically, if you have a situation where an employee is clearly not a good fit, I generally advise separate that employment, even if you don't meet that willful misconduct standard.
Mm-hmm. Yeah, and just to emphasize, there's a difference between are you allowed to terminate the person and will they get unemployment? Two totally different things. I think that kind of gets mixed up in here. Of course, if someone's calling out once a week, you could let them go if it's not FMLA qualifying, the no sick days, things like that. And you may just have to accept the fact that they might get unemployment. So to address this, you guys talked about this already. Shouldn't you have them sign on the warning that they refuse to sign to show notice? So just to emphasize, right, like you can't grab someone's hand and force them to sign a document. So if they refuse to sign, you, the employer, can just write refuse to sign, right? So just to make that clear. How about let's talk about the integrity policy. If we have an integrity policy in our handbook that sets expectations of employee behavior for a service industry, would breaches of that policy be considered willful misconduct and reason for termination? So again, before you guys just start, I just want to say this one more time. So willful misconduct means that they're not eligible for unemployment You can still terminate them though. So it may be a reason for termination, but it may not be willful misconduct making them eligible for unemployment. So why don't you talk a little bit about that policy that they have in their handbook? How would they finagle that so that could be willful misconduct?
Your best argument would be, I think, again, not knowing the facts here, but that it's a single knowing violation of a workplace rule, and it's consistently applied, and termination is reasonable given the violation of this rule. So employers can adopt all sorts of rules, right? If you have a rule that says, so it's a single knowing violation of a rule, it's reasonably enforced, and termination is appropriate for violating that rule. So if you have a rule that says you show up 1 minute late, you're automatically fired, right? That's not going to fly. That's not going to be considered willful misconduct, even though you go in and you say, well, it's a workplace rule. It says if you're late by 1 minute, we get to fire you. You violated it, so we win. It has to be a rule, the consequences of which, when you terminate somebody, is reasonable. And so if that integrity rule speaks to, for example, theft or any kind of serious misrepresentations or breach of trust, like it's got to be something that when you present your case to the Department of Labor and you say this person violated the rule, they're going to want to know how did they violate it and what does that mean for your business. And the more grave it is, the more serious it is. It's a violation of customers' privacy, there's money being taken, the better chance that you can argue that it is willful misconduct, a violation of a violation of a workplace rule.
Yeah, so maybe if this particular employer really, and they mention the handbook, if they have in their handbook and they explain in the handbook why this is so important, this is a crucial part of our business, this is what we're all about, these are the things, this is the integrity policy, it's all about our mission statement, this is the most important thing to us, right? So if you violate this, we're going to consider that to be a serious infraction. You can try to beef up that policy, and then you can't guarantee, but maybe that will make it more likely that the Labor Department would consider that to be willful misconduct if that were violated.
Yep.
All right, let's talk about this minimum payment or minimum amount of income someone has to get before they're eligible for unemployment. Vincent, do you know if there is a number, I just don't remember if it's 600.
Yeah, I don't remember the number offhand, but that was the point we were trying to make before, that the person might not have that monetary eligibility, or even if they did through other employment that preceded the employment with the current employer, it likely in such a short period of time will not impact the current employer's experience rating, i.e. their tax, and therefore impact their tax if they were employed for such a short period of time. But there still may be a hearing regarding the nature of the separation for the employee's own eligibility based on that separation. But I think the question from Jamie is generally correct, though, that there is a monetary eligibility, but also thresholds before it'll impact that current employer.
All right, so the next question from an anonymous attendee. Had an employee come in for a shift, a delivery driver. He didn't like how full his route was for the day, meaning he'd have a longer day than usual. He got upset and said he wasn't dealing with that. And under his breath, he said he was going home and left without getting acknowledgement from the manager. When the manager realized the employee left, he said he thought the employee was joking because he's always complaining, so we let him go, considering job abandonment.
You're not going to like this, but there's a whole line of cases that talk about employees who sort of abruptly leave work, quote, in the heat of the moment. Like if you look at the Board of Review cases, there's a line of cases about in the heat of the moment, and that let's assume that employee then calls later in the day and says, I'm sorry, I was angry, I left, right? I do want to show up the next day. And the employer says, no, we consider that job abandonment. It's not my sense of it based on prior research is that that's not going to meet the willful misconduct standard, and it's not going to be considered job abandonment. Job abandonment is sort of when the employee does something that clearly shows an intent to abandon work and never come back. And so that can be part of it, but then it's got to be we tried calling him and saying, you coming in tomorrow? And he ignored. And then we called him again the next day and he ignored. Like, and he took all his stuff when he left, and it's clear that he's never coming back. Like, that's job abandonment. So a single kind of in the heat of the moment leaving, and then, you've got to be able to show that you want this person, you're trying to get them back, and they're just not responding. That could be job abandonment.
And this can't be reiterated enough. And Diane, I know you've made this point a bunch of times. Nick's not saying you can't terminate his employment.
Correct.
You may that might even be the right decision to make. It just might be he may or may not be eligible for unemployment, but that we're not trying to say you have to tolerate someone walking out on you and leaving you in the lurch without someone to take a route out that day. That's not what we're saying.
How about the question about the Uber? Can we require an employee to get a ride or call an Uber if their car breaks down? I don't know how you require that, but yeah.
Yeah, I wouldn't require that. I think you can require that they show up. It's up to them to get to work. And if their car breaks down, you're just going to hold them responsible for not showing up that day. Implicit in that, maybe in your thinking is, well, they could have gotten an Uber, but you can't have a policy that says you must go get an Uber when your car breaks down. Just be expected to report to work. And if you don't report to work for whatever reason, it's not job protected, you're subject to discipline.
Mm-hmm. Okay, how about this one from an anonymous? An employee is written up for disciplinary problems, states in the write-up next time they're going to be terminated, and then the employee brings up a claim for hostile work environment, and at the same time another offense occurs. Can the employee be terminated, or must they continue working until the hostile work environment claim is cleared? Would it open the employer up to retaliation if employee states being fired because they're bringing up the claim?
Yeah, I mean, there's a lot of layers to this.
Yeah.
I mean, the fact that you're asking the question tells me you're smart. You know what's going on. And, just because somebody claims a hostile work environment does not mean that they can't be disciplined for inappropriate actions, right? But what it does mean is you're going to take a hard look, because it opens up the specter or the potential that the employee says you're retaliating against me because I made a claim of a hostile work environment. And so I think what it requires is close scrutiny of exactly what's going on and really having a good knowledge of the basis for the disciplinary action. Like, you're just going to have to make sure it's rock solid. And doesn't mean you've got to wait for the investigation to finish or anything like that. Like, if you've got a really solid basis in discipline or termination is clear in that circumstance, then you can proceed. But you're right to be asking that question, because you want to ensure that you've dotted your I's and crossed your T's.
Yeah, I don't really think it's a matter of like, can the employee be terminated? It's just going to be a matter of, are you going to be able to prove that the termination was legitimate or not? And so what does the employee have to prove that it was retaliation? And what do you have to prove that it was not retaliation, right? So you got to kind of picture yourself submitting that proof. I always tell people, imagine yourself explaining to the judge why you let this guy go, right? Like, what do you got to prove that? Before we go, I actually just want to have you guys answer a question that's in the chat, because it has to do with, they may not realize this, but it has to do with the recent NLRA decision about talking in the workplace. And the question that I'm talking about is, can we terminate an employee that appears to be spreading rumors and negativity? Can you guys just talk a little bit about that new ruling from the NLRA about, like free speech, and when can you terminate people for complaining, and does it have to be more than one person that's complaining, and what the standards are for that?
So the general rule, I think it's a good place to start with the general rule. When you say NLRA, you're obviously referring to National Labor Relations Act, enforced by the National Labor Relations Board. They're most famous for kind of enforcing the laws regarding collective bargaining, unionization in the workplace. But lots of folks don't realize that the NLRA has provisions of it that apply to even non-union employers. And one of the big key to that, one of the biggest provisions I'm referring to is Section 7, which says that all employees have the right to engage in protected, concerted activity, to better their own or their coworkers' working conditions, compensation, et cetera. And so all around that, and even in some more recent rulings, the current board really does scrutinize employer policies, decisions, disciplines, if those can be seen to be chilling employees from exercising those rights. And the board takes a broad view of that. Complaining about work conditions is likely protected under NLRA. Complaining about an abusive manager, likely protected under the NLRA. And so you do have to be really careful when you're talking about disciplining someone for something like spreading rumors or complaining, because to the extent that it impacts multiple employees and has to do with a work condition, there is some broad protection there under the National Labor Relations Act, even if you are not a union employer.
Yeah, thanks for that. That was an important decision that came out recently that I do think employers should be aware of. And as Vincent mentioned, it's got to be, if it's just one worker who's talking, that's not covered. But as soon as they bring in a second worker and they're both complaining about anything having to do with working conditions, then you got to be kind of careful.
Or even if it's just the one, but it has to do with, but it's in the context of this is impacting me and my coworkers, as opposed to this is just my own issue. That's where it starts to get into that protected area.
All right, so we have come to the end of our hour, and we did not get to everything. Thank you, everyone, for sending in those questions. If you are CBIA members, you can send those questions to me, and I'll do my best to answer them. You can also reach out to Nick and Vincent at Carmody Torrance. And so thank you, Vincent and Nick, very much, as always. And we will be back in December with our next hotline. So we hope to see you guys then. And have a good afternoon.
Thanks, Diane. Thanks, everyone.
Thank you. Bye.
Bye-bye.